CSMFO. This is Rich Lee, your co-host and producer for the CSMFO Podcast. Today I'm joined by a very special guest, Mr. Michael Colantuono. Michael, thank you so much for joining me today.
Happy to do it.
So for the CSMFO members who are perhaps new to the organization and are not familiar with you, would you mind introducing yourself?
Sure. I'm a local government lawyer, and I have been since 1989. I attended my first city council meeting a few weeks after starting at a law firm that hired me after my post-law school clerkship. And I have been advising cities, counties, and special districts ever since. When Prop 218 went on the ballot in 1996, the League of California Cities needed somebody to be a regular spokesperson for the No campaign. And Prop 218 was called the Right to Vote on Taxes Act, and there was no elected official in the state who wanted to be against that until the very end of the campaign when LA County Supervisor Zev Yaroslavsky came in. So I was the poster child traveling all over the state, talking usually against Joel Fox and other folks from the Howard Jarvis Taxpayers Association about that measure. And as you can imagine, when you've got a measure called the Right to Vote on Taxes Act, and the only person who's the lead spokesman is an obscure contract city attorney from Southern California, we lost by 1 million votes, and I got a practice area. And so the CSMFO community knows me because I regularly update them on developments on the revenue side of municipal finance. I'm not a bond lawyer, but taxes, assessment, fees is what I do.
So you mentioned the Howard Jarvis Taxpayers Association. I think it was 2 weeks ago or last week, we had the Cal Cities Revenue and Taxation Committee meeting. And towards the end, Ben Trefo was mentioning legislative update, and he mentioned that there is an initiative that the Taxpayers Association is gathering signatures for, and recollection is that they're targeting real property transfer tax for charter cities, as well as, of course, the parcel tax for initiatives to go after the what was the ruling that they had a while back?
The Upland case.
Thank you, the Upland. So I'm sure that you're following that very closely.
I am.
What are some other pivotal court rulings that you've come across over the last 20, 30 years that you think have been landmark cases?
If you think about municipal revenue authority across the broad arc, under the Constitution of 1850, there was a fair amount of local control, but nothing to protect us from the state showing up and grabbing a revenue stream or imposing a cost on you. So literally, the legislature ordered Stockton to build a railroad siding for a railroad. The Constitution of 1879, our current Constitution, was intended to protect local financial autonomy by preventing the legislature from passing special statutes, from adopting taxes to fund local services, etc. Then we got Prop 13. Prop 13 resulted, some of us are old enough to remember Jimmy Carter and his cardigan, and Jerry Ford and his whip inflation now buttons. It was a period of stagflation, with stagnant economic growth and high inflation resulting from the OPEC oil price shocks of the early 70s. And in that time, the value of a house, the nominal price of a house in California, was skyrocketing because of this persistent inflation, and because some of the economic conditions that we have now, where there's more demand for housing than supply. And the local governments all had the power to tax, and they were not reducing their tax rates as rapidly as was necessary to account for the rapid increase in assessed valuations which were tied to the marketplace. It was very well understood that people were being priced out of their homes, and this was a crisis. And Sacramento dithered. They couldn't create the consensus that our 17th century governance structures require. And by the time the legislature got around to fixing it, Howard Jarvis and Paul Gann, a couple of rabble-rising anti-government activists, got Prop 13 passed. And Prop 13 did two really important things. It capped property taxes at 1% of full market value. They used to be the sum of all the local decisions against assessed value. So I have a property tax bill in my files from the early 70s that was actually Win Firth's house in, for those of you who know, Win used to be a city attorney in Palo Alto. She lived in Claremont, which has a good school district and a community that cares about the quality of that school district. Her tax rate was 6.5%. of 1/4 of fair market value.
Okay.
So still a lot more than is allowed today.
Right.
But so the first thing it did was cap the taxes at 1% of full market value. Important. It meant that property taxes are no longer going to fund infrastructure.
Yeah.
They barely buy you a police force. The second and less visible but really important feature is that the allocation of the 1% tax among local governments is now a decision for the legislature. And that brought us all sorts of fun things like ERAF, the Educational Revenue Augmentation Fund, and ERAF 2, and the end of redevelopment, and things like it. So we lost an awful lot of autonomy when Prop 13 passed. And then since Prop 13, we've had Prop 62 and Prop 26 and Prop 218, and you've mentioned we defeated the Taxpayer Protection Act last year that would have really made it hard to fund government services. And we knew when we defeated that, we defeated it in the Supreme Court on the basis that it was too encompassing, that it was too profound a change in the financial authority of not only local government, but also the state government. But the court never said how many elements of that Christmas tree of gifts to the libertarian folks would have been enough to make it a revision, rather than, you can amend the Constitution by initiative. You can't revise it by initiative. And somewhere between everything they wanted and one piece of what they wanted is the line between the two, and the court didn't tell us where that was. So we anticipated that more measures would be coming for a couple of reasons. One is there's persistent pressure to resist government's power to fund services. And secondly, there are organizations in Sacramento who pay their bills by selling initiatives to people. The Planning and Conservation League is regularly proposing parks measures. Howard Jarvis, 3 times a generation, will come back with one of their proposals. And the Business Roundtable has been in this game for a while. The Howard Jarvis measure that's on the ballot, maybe, for 26, is motivated by a couple of things. One is Los Angeles used its charter city power to adopt a documentary transfer tax, which is paid when you record a deed for a sales transaction, to impose what was sold as a mansion tax. Mm-hmm. And it's on escrows of $5 million or more. And most of the people who are listening to us talk today are never going to own a house worth $5 million in 2025 currency. Who knows what the currency will be worth down the road. But at the moment, a $5 million house is a pretty wealthy person's house. But the Measure ULA swept in things like apartment buildings, commercial buildings, industrial buildings, condos, and the like. And it's such a high rate of tax. It's such a steeply progressive tax. I think it's like 5% on escrows above $5 million and 7.5% on escrows above a larger number. It's a big bite. Well, it produced a lot of quick sales before November, and an absolute crash in certain parts of the real estate market in Los Angeles after. And as a result, it does not produce as much money as was anticipated. And the money's going to go to homelessness and housing services. The real estate market in Los Angeles is not going to let go of that issue. They brought a whole bunch of hopeless lawsuits that were defeated by the city and its allies. But that money is going to find a way to be heard. And the Supreme Court tells us that money is speech. So an initiative sponsored by somebody is coming. I'm not sure there's a deal between Howard Jarvis and the anti-Measure ULA folks yet. But I do think Howard Jarvis is developing a product to sell and would like the Measure ULA folks to buy it in the form of money to collect signatures, etc.
That's what I asked at the Cal City's committee meeting was, are we aware of who was putting in money to gather signatures? And they weren't aware yet. Quick little trivia question for you. So I used to teach a Municipal Finance 101 course for my region for a handful of years. And I would show this clip of Howard Jarvis, who made a cameo in a movie. Do you recall which movie that is?
I don't recall what movie that is.
So it's in Airplane.
Airplane.
Yes. Okay. He's at the airport and he's getting into a taxi. And I always point him out and I said, do you recognize this man? And I'd say maybe 1% of people do. Because, I think he was dead before I was even born.
Yeah, I think that's right. He was a real estate investor. He owned apartments. Yeah. And it's worth noting the Howard Jarvis Taxpayers Association and the California Apartment Association share a building and staff. So apartment owners speak loudly in their circles.
The previous agency I worked for, I think it was the 22 election, we did a real property transfer tax. We were already a charter city and we already had a real property transfer tax in place, but we were following suit of what other charter cities were doing in the Bay Area, which was doing a tiered structure. Mm-hmm. And we reached out to two organizations, one of which was the local Realtors Association, but the other was CAA, just to make sure that they were on board with it or not, or at least get their feedback. But I agree with you that that's part of the process, is conduct the outreach and engage with them so they at least know what's happening. One of the things that you often cover and I'll thank you again for coming to our conference to present on all things that are happening in case law and current litigation. But one of the things that you talk about are water rates, sewer rates. Specifically, so there's some recent decisions that have happened. There's Pats versus San Diego, Destin versus Sacramento. And how are these influencing municipal practices that you've seen?
Proposition 218 has what I consider one really bad idea in it. And that really bad idea is independent judicial review without deference to the local government decision maker of legislative rate making. When I say legislative rate making, we're choosing policies in an infinite range, not an infinite range, but a range of equally legitimate policy options. There's no law that says you have to have uniform rates. There's no law that says you have to have tiered rates. There's no law that says you have to treat farmers and commercial and industrial and residential the same or differently. These are choices that we make, and we make these choices in order to serve the interests of our community and manage a scarce resource. But if you have independent judgment review of pure choice in a range, and it involves a whole lot of math, and the decision maker is somebody who went to law school because he didn't want to do math, you can get really bad results. So what happened in Pats was that the trial court, this was a challenge to San Diego's inclined block tiered rates, which make water progressively more expensive as you use more in order to discourage waste and encourage conservation. What the trial court did was to order the two parties, their lawyers, to each write a recommended statement of decision. And then he adopted the plaintiff's lawyer's statement of decision, lock, stock, and barrel. And the most obvious way to read that judgment is you cannot have a rate that looks to peaking factors, which is the extent to which a customer class uses more water at the peak moment, a hot afternoon on a summer day, than it does on average. And the reason that engineers and rate makers look at peaking is that peaking means a bigger pipe. Mm-hmm. If you took the same amount of water at a consistent rate over 24 hours, we could send it to you in a straw. But if you need a lot of it right now to fill a bathtub, we need a pipe. Yeah. And if you want a whole lot of it, we need a bigger pipe. So we use peaking factors. We've been using them in the water industry for 100 years now. He said you can't use peaking factors unless you have time of use data. Mm-hmm. Well, from my perspective, this is felony stupid. We've been using peaking factors for as long as there have been water engineers, and time of use data is a novel technology available to only the most resourceful agencies, best funded agencies. So the Court of Appeal in the companion case to Pats, called Coziar versus Ote, said, well, we're going to affirm the trial court, but no, you don't quite need time of use data. Didn't say what we do need, but did recognize the trial court's ruling had gone too far. We're going to need some help here. We got to get this fixed, because the current environment means unless you choose the most plain vanilla rate structure, which is uniform rates where every unit of water costs the same amount to every user at all times for all purposes, you're at risk of suit. And the outcome of that suit can't be predicted because it turns on the proclivities of the trial court. And the courts of appeal aren't any more eager to do math than the trial courts have been, and they have started to use some of the technical tools of appellate review to basically shut down appeals and defer to what the trial court did. Well, that means it's the luck of the draw on who your trial court judge is. And that's going, and these cases have produced very large refund amounts. It was $75 million for San Diego, I believe, for 1 year. I mean, they're huge sums. And the lawyers get their contingency plaintiff's fee based on a percentage of the recovery. So we represent LA in its rate-making cases, and we have a dozen cases at all times because LA is the biggest municipal services retailer in the country, I think. And they're an easy target for suit. And if you get lucky with your choice of judge, you get a new Jaguar.
Wanted to shift to appellate advocacy. Mm-hmm. So you've argued multiple cases with the Court of Appeal and the Supreme Court. What's one of the more memorable cases that you've had? And you can choose from Green versus Marin Flood, Richmond versus Shasta, CSD, or anything that rises to the top of like, wow, that was something you're never going to forget.
I have different memories from different cases. I remember my first case very clearly because it was my first case. It was back in 2012. And the question was in Richmond versus Shasta CSD, whether a water connection fee for a new meter was subject to Prop 218. And that was a pretty conservative court. This was when the Pete Wilson and George Deukmejian appointees still dominated that court. And I still managed to eke out a victory just because the measure just didn't have language in it that would allow you to really, how do you do a majority protest proceeding if you don't know who's going to pay the fee because you don't know who's going to develop? So I won that one on common sense grounds.
Okay.
I remember arguing Wild versus Dunsmuir during COVID. I had two arguments on the same calendar, two different cases on the same calendar during COVID.
Oh my gosh.
When I was in my conference room down the hall speaking to a camera because everything was remote during the epidemic. And I remember very clearly the logistics of that day of handling two cases and doing it over the internet. And the court issued an order for supplemental briefing a few weeks before argument, asking us to basically unpack a footnote in an attorney general's opinion from the 1950s. And there were no libraries that were open that I could go to, and finding these materials, I asked the court, do you have the attorney general's opinion? They said, it was actually a ledge counsel's opinion. Mm-hmm. And they said, we don't have it either. And so I found some law librarians at Berkeley and the state law library who were willing to send a body into the building and look for me. Wow. And it really does take a village. We worked that out and we made sense of it, but it was a memorable experience.
Wow. How do you see appellate advocacy shaping municipal budgeting and policymaking? Like, from your perspective, how proactive should finance directors be in anticipating legal challenges?
You need to have your radar up. Sometimes you can smell a challenge coming. If the guys with alligator shoes and black briefcases show up at your council meetings, you know. Sometimes lightning strikes. You adopt something, there's no controversy, everything's quiet, and then suddenly a lawsuit comes out of the blue. Not usually the case. Usually when somebody's preparing to challenge you over something important, And so my advice is when you see it coming, make sure your lawyer knows about it. Mm-hmm. And my advice to your lawyer is that if it's a public finance topic, make sure that Cal Cities knows about it. Because there are other cases that you may not know about and they do. There are resources that they know about and you may not. It really takes a village, and let the village help you.
You mentioned at the top that your area of expertise, municipal revenues, and there have been some recent cases with franchise fees. I remember you talking about one of them, which was Zolli versus Oakland. Mm-hmm. Can you highlight, again, what our members can learn from these rulings and how they can apply to future revenue strategies?
Lawyers like to say that bad facts make bad law. What happened in Zolli was that Oakland rebid their solid waste and their recyclables contracts. The large players in that industry did what large players do in cities like Oakland, what looked like influence peddling to those of us outside City Hall. It got pretty redolent, shall we say. And the grand jury wrote a highly critical report. It ended up in the paper. That attracted the plaintiffs' lawyers. The city got sued. And when the city deployed all the usual defenses for that kind of a case, saying, look, landlords don't pay the fee tenants do, so you don't have standing. And the fee that we're talking about here is a franchise fee that comes out of your trash rate and goes to the hauler. It's not coming directly out of your pocket. All of those should have been good defenses. And they worked in the trial court, and they partly worked in the Court of Appeal, and they didn't work in the Supreme Court, making those defenses less useful to us in other cases because the court just couldn't stomach the idea that that kind of apparent misconduct Campaign contributions go in here, and a big chunk of change comes out of the pocket of ratepayers into the city budget there, is beyond the reach of judicial review. So bad facts make bad law. One of the things I say to my clients, and I would say to our whole CSMFO audience, is try to stay out of the paper. And I don't say that glibly. What I'm really saying is that controversy produces internet coverage, which produces plaintiffs' lawyers. So if you can communicate with your stakeholders in a way that prevents surprises, make people feel heard, make them feel respected, make them understand that you're not raising rates because you want to impoverish little old ladies, you can tamp down the potential for big sparks of confrontation that will produce the news stories that produce the plaintiffs' lawyers. So I think those of us who are in the revenue business in California for government basically must stay in constant communication with our stakeholders. We need the community to know what we're doing and why.
I think it was 2 mid-year budgets ago, our finance director was presenting to our council, and they were going major revenue by major revenue, and they were following the trends. And one of them was franchise fees, and they noticed a decline. And they had asked, do you know what the impetus behind that is? And I had done some research on it, a few years ago, looking at other municipalities in the county that had a utility users tax. So I knew that was largely due to telecommunications and cable TV decline. People are cutting the cord. Which brings me to I'm curious if you're following the Santa Barbara case.
I am.
Okay. I believe it's in litigation now.
It is. It's in the Court of Appeal, and argument is coming.
Okay. But from a layman's perspective, before the advent of the internet, people were getting their entertainment largely through cable TV. And it was just a shift in consumer behavior, right? Mm-hmm. You're trying to save costs. You're able to get similar, if not the same content, just by different means. So what my understanding is what Santa Barbara's city attorney did was they looked at their ordinance and said, this is modern enough to challenge that this should be applicable to streaming services. I'm just curious what your perspective is on the interpretation.
When George W. Bush was president, maybe this was HW, it was HW, in the early 2000s, the federal government stopped taxing a portion of the federal telephone tax base. And all of our utility users taxes incorporate the federal telephone tax base in their definitions. Okay. And so we were at jeopardy for losing a big chunk of our telephone users tax. And so we trotted out an amendment to the standard ordinance, because we all adopted the same ordinance. It was negotiated with the big utilities in the 60s, to say we didn't intend to shrink the base in the way the federal government did. We mean the base of the federal telephone tax as it was understood up until the Bush administration. And there's a case out of Norwalk in which the second district said, that's right. You are entitled to say we intended that and the federal change was not imposed on us. But during that uncertain period between when we started risking the revenue and when the Court of Appeal finally said it wasn't at risk, a lot of us amended our telephone tax ordinances and the way we sold it to the public was you're already paying it, and we're trying to be technology neutral so that those rich people with their fancy new smartphones that you can't afford will pay at the same rate as you who've got your dumb phone and your landline. It became important in a lot of the campaigns in particular cities to say, but we're not going to tax ringtones and digital downloads because those were all the rage, and people just outraged that they had to pay a tax in order to get Whitney Spears as the song on their phone when their mom calls. Whitney Houston, I guess, Britney Spears. And the Santa Barbara ordinance isn't an old-fashioned telephone tax. We're talking cable tax or television tax. Right. And they didn't find it necessary to adopt that no digital downloads language. And so they were in a very good position to say, we don't need to go to our voters to amend our ordinance to apply to streaming services. Our tax is always applied to streaming services. We just never enforced it before because there wasn't enough money before, and now there is. So if you're interested in scooping some of the candy that Santa Barbara may whack out of the piñata for us, start by looking at your ordinance, because if you've got the digital download language, which I wrote for many of you, it's not going to work so well.
What was that, a month ago, we had a revenue enhancement study session for our council. And of the 4 options, one of them was utility users tax. And I know, going back to, I think, the year 2000, statewide, the success rate for new or enhanced UUTs is about 32%. So I think of the options, it was the one that performed the worst at the ballot box. And I mean, one could argue it is a regressive tax.
Well, the biggest problem is that it's a tax on voters. The people who are deciding the yes or no can't escape the responsibility for paying it personally, because we all use utilities. I remember Trent Lott, who was the senator from Louisiana, used to say, "Don't tax me, don't tax thee, tax that fellow behind the tree." Well, with utility users taxes, it's not somebody else, it's you, it's personal, and therefore it's much harder to sell.
Yeah. I wanted to transition to water-related fees and some policy intersections. You've advised on groundwater extraction, tiered water rates, water district charges with AB 1827, now law. How will bond counsel and finance directors adapt their rate setting models?
We have been successful in getting some help from the legislature on water rates, most of it procedural. So there are a couple of bills, Assemblyman Papin, who I'm sure you know, sponsored to try to protect tiered water rates. We have a short statute of limitations now. It's 120 days from when the rates take effect, not from when they're adopted. And you have the right to impose a duty to exhaust administrative remedies by coming to the rate-making hearing and naming your legal theory. And if you don't do that, you can't sue at all. And if you do sue, you can only sue on the legal theories that you've raised. The burden is that we also have to provide written responses to those comments before the water rates are adopted. So we now have a bunch of procedural protections, and the litigation is on the record, which is important. We've gotten some written decisions where they brought in an expert after the fact to second guess what we did, and the judge bought it. So it's on the record, the evidence that we looked at, that we responded to, that we made findings about. So we got a bunch of procedural help from the legislature. We don't have much substantive help other than the 2 Assemblymember Papin's bills, because it's in the Constitution, and the Constitution is itself the problem, using very broad language and asking for independent judgment review. I think we're either going to need a constitutional amendment, which might come from our friends on the environmental side in the right environment, or we're going to need the Supreme Court to take one of these cases and try to rein the trial courts in. I'm not especially hopeful that the Supreme Court can save us, because even if they do, they can't make trial court judges think about math any more than I can.
I'm recalling there was a recent case, it was by the Supreme Court. It was the El Dorado Hills, and there was someone who was challenging their impact fees.
Traffic impact fee.
Correct.
This is Sheets versus El Dorado County.
Thank you. I know you, what was it, 3 or 4 newsletters ago you wrote about it. Perhaps on an elevator ride, and a CSMFO member isn't aware of how that potentially would impact their organization. What would you say to them in the 2 to 3 minutes that you're on the elevator with them?
We all know that local control used to be a value in Sacramento until we started talking about a housing crisis. And now we get literally 2 or 3 dozen housing bills a year, all stacked on top of each other. Well, development impact fees are the fee expression of the politics of housing. So we're getting lots of statutes regulating how we do development impact fees, and we're getting legal challenges from the development community. What Sheets was about was a pretty technical issue. If we impose a fee as a condition of approval, a one-off ad hoc exaction is the word we use for it, we have to do what's called Nolan and Dolan analysis. Nolan says that the fee must mitigate impacts that have a logical connection to the project. Nexus is the lawyer's word. And Dolan says, and the amount of the fee must be at least roughly proportionate to the extent of the impact that development has. So Nolan and Dolan analysis is understood to apply to one-off fees.
Okay.
What Sheets says is it now applies to fees that are adopted legislatively across a range of fee payers. It's not that, I think Tim Seufert from MBS said it's a nothing burger. And the reason he says that is because AB 1600 also already requires us to do a nexus study and to show the connection and show the proportionality. What I think the takeaway is not Sheets or El Dorado or legislative or ad hoc. The takeaway is development impact fees have gotten risky because of our political environment, and you really need to do your annual reports and your 5-year reports. And I know they're a pain in the tuchus and you'd rather not do them, but you really, really, really need to do them. And if you don't want to do them, there's plenty of consultants who will take your money to do them for you.
You brought up this towards the top of the interview, but this, from my perspective, this is a consequence of Prop 13.
Oh, yes.
Because we don't have the resources to pay for infrastructure, hence AB 1600, to give us the ability to provide some funding, but not all.
I was spending some time in New Zealand, which is a beautiful place, but it's not that wealthy a country. And they have a real need to build housing and to stimulate their economy. And the challenge they have is how to accumulate the capital necessary for infrastructure. I mean, Wellington, the national capital, is putting untreated wastewater in the ocean because they have challenges in their economic environment accumulating the capital necessary to provide infrastructure. And they're very interested in things like tax increment financing and development impact fees. But building the administrative structures to collect and enforce them and building the political will to impose them is the challenge there.
I'm recalling a session, this was the 2020 conference. I don't recall if you were there or not. There was a consultant who was partnering with then city manager from Placentia, it was a case study. They were the second city, I believe, to do EIFDs. Mm-hmm. And what I recall is their EIFD is coterminous with their former redevelopment agency. So I kind of raised my hand and I said, how are you dealing with the existing debt for the redevelopment agency? And the secret was they didn't have much debt.
Got it.
So they had, as you know, they had to get buy-in from Orange County to make it work. Because if you don't have one of the taxing entities to give you the green light, it's a no-go.
Right.
But I know there are some of our colleagues who look at that as kind of redevelopment 2.0 light. Mm-hmm. I don't, other than Placentia, I don't know too many cities that have done EIFDs, but perhaps you do.
No, they're very rare. These are enhanced infrastructure financing districts, which are a form of tax increment financing, but they require the taxing agencies, city, county, special district, to agree to give up some of their future income stream. And none of us have an incentive to do that, except very occasionally. If you're solving a serious brownfield problem and there's going to be a significant upside for everybody, if you've got a greenfield situation, it's much less likely.
I'm recalling the pitch to Orange County was they saw the benefit of Placentia improving its downtown area. So that was a win-win. Going back to the impact fees and development charges with AB 516, you mentioned the AB 1600 reporting. With that coming online, what are some operational changes that agencies should implement to remain transparent, compliant, and audit ready?
The essence of it is that the development impact fee should be built around a capital improvement program or a subset of one, saying what facilities do we need to serve what area of development and what are we going to build and when we're going to build it. And these are all engineers' predictions of the future. And engineers may be good at math, but they don't see the future any better than the rest of us do. And capital improvement plans get out of date very quickly. And so the key is to use your annual reports as an opportunity to rethink how current is our CIP, how likely is it are we going to get these things done within 5 years? Because if you wait for the 5-year report and then have to fess up that we're not going to spend it and here's why, you're much better off if you can see that problem coming and get out ahead of it.
What have litigated nexus and connection fee cases like Hamilton and High and Palo Alto and Barajas versus Petaluma taught us about defensible impact fee programs.
Well, Hamilton and High was, bad things happen to good people. That was a completely ordinary parking in lieu fee. Developer, give me 26 units of parking for your mixed-use project in downtown Palo Alto, or if you'd like, you can give me 0 or fewer and pay an in lieu fee, and I'll use the money to build structures elsewhere. Developer opted into that deal. The city agreed to do it, and the developer later said, give me my money back. And the courts, quite frankly, because it's a very smart panel of judges who used to be federal lawyers, misunderstood the interaction of California statutes and the Nolan-Dolan constitutional standard and imposed AB 1600's reporting and prompt expenditure rules on in lieu fees. Well, you can't predict when you're going to have enough in lieu fees to build a parking structure.
Right.
They have a very different rationale. So that one is just be aware of how challenging it is to explain what we do, and work on your staff reports and your PowerPoint slides to speak not just to math majors, but to English majors. Use pictures, use graphs and numbers so that you can tell a compelling story about what you're doing and why. What happened in Barajas versus Petaluma, my firm did the amicus brief there, was that a challenger claimed that the city's use of an 8-year-old nexus study somehow invalidated their 1-year and 5-year reporting obligations. And until recently, when there was an obligation to update your study every 8 years, there hadn't been any obligation to update it as long as it was still a sensible expression of what you were going to build and who was going to benefit from it. So Barajas is sort of an example of people get ideas in their head about what's right or what's fair or how government should operate. And if we're not fulfilling their expectations, they'll sue us and see if they can push the law in an adverse direction. We won that case because there wasn't any law for their side of the case, and they seemed pretty unreasonable. But that takes me back to something I said earlier. We need to stay in constant dialogue with our residents and our businesses about what we're doing and why and what things cost, so you don't get somebody who gets a bug up their ear about, that's not fair and I'm going to sue you.
One thing that my city does, I think, fairly well is we keep the public abreast of what's happening development-wise. So all of the private development happening, we have a GIS layer that shows where it is, who is the developer, how much they paid in impact fees, and there's just information there, and it's all kept up to date. One thing I think we also do is we show what developments we're working on as an organization, public improvements, parks, buildings, just so, to your point, that they're aware of what's happening. And I'm recalling an effort that we had where, just a little bit of background for my organization, about 31% of our households are monolingual for a non-English speaking. So I have to keep perspective is that those members of the community are likely not reading the newsletter, not watching council meetings, not really engaging with the organization. So finding ways that we can, and I should also add, not following us on social media. So there is a portion of the population that we need to reach out to that are impacted, that need to stay updated, just finding alternative ways to interact with them. And that can mean translating into different languages, going to places that they frequent to go to them. But at least that's something that my agency is doing. I know a lot of our members are doing that as well because we live in California. And I mean, there's half a dozen languages that are demographically at the top along with English in my community, especially on the peninsula.
Wow, the Los Angeles Superior Court does business every day in more than 200 languages.
Wow.
What we're talking about ultimately is acquiring information, interpreting information, and communicating it. So here's what's going on in terms of development, here's what's going on in terms of how we fund services. And then analyzing that and extracting from it the talking points that real people can absorb and care about,
right.
And then getting those talking points across. And it occurs to me that artificial intelligence is going to make all three of those tasks, gathering, analyzing, and communicating, much easier. And I think all of us need to be getting more comfortable with AI tools and beginning to use them in these ways. But you can dump a whole lot of data into an AI tool and ask it to tell you what the significant business issues it presents are. You can ask it what the trend lines are. You can ask it to identify any anomalies in the data. And then once it's given you that answer, you can say, okay, give me some bar charts which depict what you just told me. Give me some pie charts that depict what you just told me. Give me some clip art that are related to the insights. And before you know it, it's writing a staff report and giving you a PowerPoint.
Yep. In fact, just a couple of days ago, I did a simple survey for the cities in my county to ask them 3 simple questions. One of them was, does your agency use AI?
Do you admit it?
And the second question was, do you have an AI policy? And of course, I made the survey anonymous. The third one was, what are the AI tools, if you answered yes to the first question, that you're using? And it was the most readily used ones, ChatGPT, Grammarly, Copilot, Otter.ai. I mean, I'm probably forgetting half a dozen more.
Otter is a problem. The reason that Otter is a problem is that it does not assure you of confidentiality of the information that it absorbs. And if you install it thoughtlessly, which is to say if you do the easy thing, it plugs itself into your calendar and automatically sends an Otter bot to attend all of your meetings. So we acquired a law firm, and we have 3 new lawyers in our organization. They show up at our first team meeting, and suddenly there's this chat box saying that Otterly is taping a conversation among lawyers that we'd rather not have taped, thank you very much.
Right.
So I think of Otterly as kind of a bad virus, but I know it's powerful for people who use it. You just need to use it thoughtfully. Yes. But I read something that said something like 60% of America's white-collar employees are using AI, but only 30% admit it. And people don't admit their use of it because they think their bosses or their peers will think less of them. And what I've tried very hard to do in my organization with my partners is to make it clear, we welcome AI. We want to know what you're doing. We want the benefit of your insights. Because one of the challenges with AI is that nobody knows how to use it well. AI doesn't know how it should be used. The people who write AI are not lawyers. They're not finance directors. They're software. So nobody knows how to use it. And we're going to figure out how to use it sort of incrementally as people try things and it works. And so we need to share our successes and get the rest of the team doing it too, which is hard to do if people are embarrassed by their use of it. So my advice to the leaders of all sorts of organizations is get a good policy in place and don't just stick it on a shelf. Make sure people know what's in it and you talk about it periodically. And encourage your team not only to use tools appropriately, but to share their wins.
Absolutely.
And a lot of people fear that if they tell the boss they're using AI, that he's going to double their workload.
I'm recalling, gosh, what year was that? I want to say it was 22 is the first year we had an AI or automation session at the CSMFO conference. And it was standing room only. There's definitely, I mean, it is probably the number one topic we've had over the last 3 or 4 years. I've been in government for 20 years. And to say that government tends to lag in terms of technology, from my perspective, it is true. But I think I agree with you. There's certainly opportunities with AI. I'm an AI proponent myself, but I think responsible policymaking needs to go along with it.
Yeah, and the critical thing about AI tools is you need to understand what degree of confidentiality and security they're offering you, and you need to understand how the tool works, what it's doing, and what you're getting. And then be very clear that what you're getting should be treated like the work of an intern. Yes.
I just have a couple more questions for you, and this is more of a overarching career perspective, since you've been in this profession for, I think, over 30 years now.
36, I think.
Okay. So you taught at Berkeley Law, and you received the 2010 Public Lawyer of the Year award. You served as an adjunct professor. And what is your motivation for your dedication to public law?
Lawyers, by definition, help other people achieve their goals. We are not in the business necessarily of achieving our own goals. And there's necessarily, at times, a gap between what we think is good and what the client wants. And we have to have some sort of self-justification, some script that we read to ourselves about why am I trying so hard to help them do something I think is stupid, wrong, or immoral. And the answer for me is that I'm serving local democracies that get to make choices. And I don't live there, I don't pay taxes there, it's not my choice, but I can feel good about helping them make their choices. So it's public service, like the rest of us. It matters a lot in the world. It's fun, engaging, and intellectually challenging. And most of the time I'm working with good people trying to do good.
Last question for you. What advice would you give finance officers who want to gain confidence in legal risk assessment and litigation avoidance?
I think two tools suggest themselves to me. One is acquiring a certain amount of information about what the rule set is. You need to come to conferences like CSMFO and hear the legal updates, and use the tools like the League's Municipal Revenues Handbook. So you need a data set, and you won't acquire that in one weekend with 2 cups of coffee and a couple of books. It's incremental. You need to stay current. But the second one, I think many of your members already have in spades, and that is sort of social awareness, the ability to be sympathetic to, maybe even empathetic with, the perspectives of all the folks affected by the decisions you're making, so that you can anticipate points of friction, sources of controversy, and landmines that you might step on. So you don't need to be a rocket scientist in municipal finance law to know you've got a challenge if there's a bunch of lawyers and an angry union rep at the same meeting on the same subject. So that social awareness, that social psychology, that sort of seeing the human and the other across the table from you, that's a really important skill set. And most of us have it, and we should honor it and use it.
I agree with you. I don't know if you know, Frank Benest.
Yes, the longtime Palo Alto city manager who was the king of mentoring and succession planning.
Yes. One of my favorite charts of his, you've probably seen it, where it talks about your career arc and your technical skills versus your interpersonal skills. And as you go up in your career, you're relying less and less on your technical skills and more on your interpersonal skills. I have found that to be true, and I appreciate it every time I think about it, that he shared that with me, 10 years ago. But yes, absolutely right. He is quite the proponent of coaching and mentoring, especially through Cal ICMA.
There's something I read somewhere that along the lines of people will rarely remember what you told them, but they will remember how you made them feel. And so making people feel good about themselves, about you, and about your interaction with them, even if the news is bad, is a goal to be aspired to.
So on that note, I want to thank you for joining me on the CSMFO podcast, and thank you for your time and for hosting me in your office at such a beautiful drive out to Grass Valley. And so again, thank you, and look forward to having you at our conference again this year.
I'll be there.
Awesome. Thanks.
Thank you.